third case on this morning's docket, case number 113562, State of Kansas v. Lee.
May it please the Court, Assistant District Attorney Boyd Isherwood on behalf of the State of Kansas. And Your Honor, I'd like to reserve 2 minutes rebuttal time.
2 minutes is granted.
Thank you. Well, I think the good news here today is that we've kind of already done this. I think courts have determined that there is to be no retroactive application of the Apprendi-based decisions. I don't see how this issue is any different than what the court has addressed before. I know by Supreme Court rule we're not supposed to read in to this court's denial of a petition for review, but in this respect it's difficult to follow that rule in that very recently this issue was before this court in a petition in Burge, and the court denied the petition for review. In addition, in this particular case, we have an issue where the defendant would be barred by res judicata, as he has brought this claim before and been denied this exact claim. While preparing for argument, I reviewed a number of cases. There was a quote, of course, I failed to write down where it came from, but I don't know that it's important. And it basically is, it's fully consistent with the government of laws to recognize the finality of judgment may bar relief. And that, I think, is what we're talking about here today. I understand that there are overruling decisions, and we're past the point where we automatically apply overruling decisions to cases that are final. We no longer do that. Unless the court has any questions on this matter or any of the issues briefed by Mr. Ney, we respectfully request that the district court's decision be overturned.
Any questions? Thank you, counsel.
Thank you.
May it please the court, Richard Ney appearing on behalf of the appellee, Amanio Lee. Well, I mean, you have it before you, as the state said. Fairness or finality? State just wants finality. We all know, every one of us here as lawyers and reading the law, that Mr. Lee's sentencing in 1995 was unconstitutional. It was wrong. We all know, and excuse me for saying, but this court got this issue wrong in Conley and in every successive case after that.
Up until last week in State v. Warrior, that I think came out last week. Maybe I'm speaking ahead of myself, but we've got it wrong every time.
Right, up to 2013, yes, Your Honor. 100 cases or so. In fact, I was one of those counsel that always got chided for raising Conley, or the Conley issue, after Conley had been decided. But Mr. Lee was right, and the court was wrong. So when I'm wrong in situations, I guess I have to make amends for that, or I have to deal with that. But what we want to say is we want finality. We don't want Mr. Lee to have his rights. Now we look at this, and the state says, well, this is it. We have Gould, and Gould said, well, Apprendi, we're not going to do retroactively. And Whistler said the same thing. But we have raised a fundamentally different issue here. And I would point out in passing that in Soto, this court said it wasn't reaching the issue yet. So we're here because you haven't said. But we may be here anyway. The district court here finally got it right, that there were constitutional rights entitled, that Mr. Lee was entitled to in 1995 that he was denied. He was denied the right to have a jury determine his sentencing, and he was denied the right to have his sentence determined under the Alien procedure now beyond a reasonable doubt. Let's remember, this was just preponderance of the evidence then. And we've looked at this, and although this court has talked about the difference between jury and judge sentencing as not retroactive, it hasn't talked about the issue beyond a reasonable doubt. When you look at Teague and you look at the cases that follow, what's one of the exceptions on retroactivity, as we pointed out? Whether the new proceeding, the new law, if you will, would create a situation where the fact-finding process would be impaired. And there's a big difference in fact-finding if you're finding beyond a reasonable doubt as opposed to by a preponderance of the evidence. So we would certainly submit that this is a Teague exception. But frankly, I don't think we even have to get to Teague. Because this is not, as we have pointed out, a new rule of law. Read Jones, then read Harris, and read McMillan. It is clear from Harris, which Alien now specifically overrules, but that Harris was dead on arrival. Justice Stevens, Justice Thomas, and Justice O'Connor all said, this just can't be law. It doesn't exist in a world with Jones. And they were absolutely right. And that was said repeatedly. This court didn't hear that or didn't adhere to that. You backed the wrong horse. I mean, that's the point. I mean, if you look at Harris, it was dead on arrival. If you look at those opinions and you look at Alien, basically says, you know, we were wrong and we were always wrong.
Well, how do you respond to the explicit language that we've had in numerous cases up until a couple of weeks ago, Moncla included, which says, is specific that Alene-type challenges cannot be raised in motions to correct illegal sentences. You seem to try to create this is more of a statutory interpretation as opposed to a constitutional challenge, but it seems to me you're relying on a constitutional challenge, which we've said is not permitted in instances such as this.
Well, you're absolutely right. It is.
We said that, like I said, up until a couple of weeks ago, that's what we've said.
Well, but in Gaydon, which is from 2006, you said the opposite. You said a motion for illegal sentence under an Apprendi situation was not a constitutional attack. It was an attack that, and I'll quote the court, I'll quote this court, because procedurally, the statutory scheme for upward departure had been eliminated by the decision in State versus Gould. A sentence for which no statutory authority exists does not conform to statutory provisions and therefore is within the meaning, the definition of an illegal sentence. That's Gaydon. That's his court. I'm following all of you in that decision. And we also would cite Kessler from 2003. And in fact, this court, although the state cites Mitchell on this proposition, we cited Soranaki from 2006 as well, which denied the issue but didn't say the defendant did not have a right to bring this by illegal motion to correct illegal sentence. So if the court's taking that position now, you're making a different stand than you made in Gaydon and other cases.
My understanding of the rationale behind that was that after Gould, this court said 4716 was void, unconstitutional on its face, therefore null and void, therefore there's no statutory provision that can be applied, which obviously then the sentence couldn't conform to non-existent. I understand that. We have never said that the current statute is unconstitutional on its face.
But it is.
Well, but we haven't ever said that.
All right.
And if we're talking about as applied, then we're talking about a different scenario. The only way you get to the analog of what we did before is if this is unconstitutional on its face and null and void. ab initio.
But I'm not sure how you can say under Gould that the statute there is unconstitutional, and then under Soto that it isn't on its face. And I think that's what you really are saying in Soto, but it's up for this court, obviously, to make that explicit or not explicit. And in fact, this court in Soto said we're not reaching the issue of retroactivity.
We've never said that. We haven't said that yet with respect to Alene or however you pronounce it.
All right. Well,
We've
I'm
never
just.
said that, have we?
I
have to make that determination to make your argument work is all I'm trying to get at.
Yes,
Do you
Your Honor.
agree with that?
I do agree
Yep,
with that.
okay.
And obviously, if you'd said it, I would have told you said it. But you said it, I think, close enough in Gaydon and Kessler and Cirenati. But that's my position. But let's look again, too. We're tied to Teague, but we're not. Again, we submit, one, as I stated, that this was a decision dictated by Jones, and that's an exception in Teague. If clearly the writing is on the wall, and this court keeps following bad law, you can't hide under the cover of, well, it's not retroactive. When we get to equities here, which is something this court can look at under Vaughn, under the Vaughn case, of how we apply retroactivity or whether we apply retroactivity, if we're going to talk about it being retroactive, though our position, Allen, is just an explanation, a clarification of Apprendi, not an extension.
As a court that is required to follow the U.S. Supreme Court decisions when they interpret the U.S. Constitution, what do we do with Harris?
Well, I think that the Supreme Court itself acknowledges that Harris was wrong, always wrong, and that they were saying that for years.
But they said they still issued Harris, and we were still bound by Harris.
Well,
They
Harris,
can say Harris was wrong, but we can't say Harris was wrong.
I understand that. But again, who should pay the penalty here? Mr. Lee? Should he serve another 15 years before parole eligibility? Because, oops, we followed the Supreme Court. Again, I think you can look at the equities, and Vaughn says you can. Mr. Lee raised this issue, and his decision in that didn't become final in a 1507, or another proceeding under illegal sentence, until 2011. So let's take this scenario. Suppose he had raised this issue a couple years later, and this was still pending when you decided Soto or when Allen was decided. He wins. So what should we say? Bad timing? You raised it too soon? That's a unique situation. But I would say to you that this court has always been bound to follow the Constitution of the state of Kansas and common law. Remember, Apprendi and all of the other cases were based on common law, as Scalia and Thomas has said. It was based on the common law, which was codified in the Kansas Constitution to say, under Section 5, the right to a jury trial is inviolate, which was the law. But Mr. Lee has his right to a jury trial violated in 1995. So that was the law then. And interesting enough, Mr. Lee's case did not become final until Jones was the law. Jones was decided 7 days before Mr. Lee's case, his direct appeal, became final. So the law that applied to him at the time was Jones, which was the right interpretation until Harris, McMillan clouded the waters. So again, this has been presented to a district court and denied under the wrong reading under Conley.
Is everyone sitting in prison right now that didn't have their aggravated factors determined by a jury, illegally incarcerated or unconstitutionally incarcerated? I mean, we can go back to indeterminate sentencing. There was no procedure for juries to make a determination on sentencing, especially when it exceeded the statutory bounds, and the same thing prior to Apprendi.
But Allen was based on increasing the mandatory minimum.
Right, exactly, right.
Okay, and so we're not really talking about the indeterminate sentences. Well, let's talk about those people who got the hard 40 and hard 50 then. And my answer to you is, I don't know how I can logically say anything but yes to that. Again, there may be some permutations. Again, Mr. Lee raised this to a district court before this proceeding. He had it, and under Vaughn, that's one thing the court should look at. The equities here is something this court should look at. But again, under Danforth, this court can say, we're going to say it's retroactive whether Teague would require us to or not. Again, there is no Teague is not a constitutional mandate on retroactivity. It's some guidance, but Teague itself and Danforth certainly says a state can make something retroactive whenever it wants to. So I think what you have to look at, I mean, of all the factors we've raised of why this, one, isn't retroactive under Jones, and two, even if you say it is, that it defeats the Teague argument. And again, we go back to the Section 5 argument, which says he always had a right to a jury trial. But I think what we want you to look at too is, have you ever said, has it ever been raised, that the proof beyond a reasonable doubt was not retroactive? You've talked about jury versus judge and Apprendi, but you didn't reach in Gould the proof beyond a reasonable doubt, or I submit, at least as far as I can tell, you've never dealt with that issue. And again, that's an issue of constitutional magnitude. But if you look at the jury trial protections under Section 5, those always existed. They existed since 1859 or so when the Constitution said they did, and they existed before that under common law. That's the whole issue of Apprendi, the common law rights. So,
Do you have any cases anywhere that allows the remedy you're seeking, that allows that someone seeking a collateral attack based upon an Apprendi raised issue, once this, by what I mean by collateral attack, is sentencing has been completed, serving time, files a motion to object to the sentencing based on a violation of Apprendi or a lien? Do you have any cases where that's been successfully
based on Apprendi?
Yeah.
Well, I mean,
anywhere
again,
on a collateral attack?
On collateral attack.
All right.
Again,
Yeah, a lien, really.
Of a lien. No, let's
Has
just start with
anybody anywhere gotten a lien relief in a post final direct appeal?
well, I think it's pretty early for that, Your Honor. And
I understand that, but
Candidly,
you don't have anything from federal court or state court anywhere yet.
well, we cited a federal court concurrence.
Which case was that?
Creighton versus the United States, the Seventh Circuit. That was just last year. And in Creighton, Judge Williams was talking about, it says, Allian altered our understanding of the bedrock procedural elements essential to the fairness of a proceeding by establishing a new class of facts that constitutes a crime and thus must be found by the jury beyond a reasonable doubt. It's at least an indication.
Was that a collateral attack, or was that on direct appeal?
That it was a collateral attack. I'm fairly sure. But if you look at this, again, I just think this is the first case for you to decide on that. If you want precedent, I mean, this is the court that sets that precedent for the state of Kansas. And frankly, in conclusion, I just have to say, who should be punished here? In due respect, again, the court got it wrong. Mr. Lee had it right. And it's a finality or fairness. And we just shrug our shoulders and say, well, gee, too bad. We all agree he was sentenced unconstitutionally, but he pays the price for our mistake. Unless there are other questions.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
You reserve 2 minutes for rebuttal.
Thank you, Your Honor. Well, I think what Mr. Ney has expressed is the one side of not applying things retroactively that can maybe tug at the heartstrings. It's always going to be that way. There was always going to be sub-apprendi, there's always going to be sub-alien, there's always going to be someone before the person that gets the relief. That is just, there. It's going to happen. And one of the things I'd like to comment on the argument, specifically cherry picking the case of Jones because of a mathematical calendar type of exercise, Mr. Ney can find that this case is pending while Jones was decided, is why stop at Jones? Jones wasn't the first case that talked about it, as he indicates, that's in the Constitution. And so when if you just trace it back, it didn't go like this. It didn't go that the earth cooled and then there was Jones, or the earth cooled and then there was Apprendi. They're always based on something else. And the slippery slope of that type of procedure would be that every case is retroactive. That's the slippery slope there.
Should it make any difference that a defendant, or actually by that time inmate, has raised the issue very specifically before a lien came down? Should that make any difference that there's been an effort to get it before us?
Unfortunately, for the defendant, it should make a huge difference, and it's the entire process of res judicata. And Mr. Ney wants to cite to Vaughn and the factors in Vaughn, and he does an excellent job of looking at almost all of those factors, except for the third factor entitled res judicata. How many procedural events, how many long-standing rules of this court are we going to be asked to avoid in order to provide relief to the defendant? If you want to look at fairness, just straight fairness, why don't we look at the fairness to the victim's family in this case? There's an avenue of fairness that Mr. Ney doesn't speak of. In any event, I believe that this court has pretty much made a decision on this issue with respect to retroactive application of Apprendi-based decisions. There's no reason to chase this genesis back. It's either new or it's old. If it's a new rule, it doesn't apply. If it's an old rule, he already tried to get application and was barred.
You agree in Gould, this court declared, what was it, 2147-16 unconstitutional on its face.
Oh, sorry, yes, Your Honor.
What can you answer Mr. Ney's question? What's the difference now? How can we say that the Hard 50 was not unconstitutional on its face when we were dealing with maximums in Gould and we're dealing with minimums? What's the difference? Why wasn't the Hard 50 unconstitutional on its face, which we then said is null and void?
Well, I don't know if I'm answering I think I'm maybe too specifically answering your question. I've never thought that the Hard 50 statute was found unconstitutional on its face because there was the one factor that only relies on prior convictions, and that is an historical exception to Apprendi. But I don't know if that's answering your question.
Well, I think what you're suggesting is that Gould was wrong when it said that.
Well,
it was wrong when it used the term on its face.
Not necessarily Gould, because
Well, that line of cases, if I said the wrong case, but the bottom line, you're just saying to the extent the court said on its face before, that was incorrect, and it certainly shouldn't be extended in this situation.
I don't feel that it should be, but I don't know that I don't know that
Not necessarily, because 4716 didn't deal with the prior conviction. The Hard 50 has the prior conviction. You're saying the distinguishing factor here is that it may be unconstitutional as applied to almost everyone. There may be that one person out there or that small segment that had the prior conviction that would not require separate fact finding.
and maybe solely the prior conviction. I don't know if it gets confused if there was the prior conviction plus another factor.
Right.
But yes, but furthermore, I don't know that it matters. Even if it was found to be unconstitutional on its face, it's a great starting point to then suggest, well, since it's unconstitutional, since we found on Friday it was unconstitutional on its face, then what happened on Monday must have been a violation of his rights. Now, where the mistake is made is to say, therefore, he automatically gets relief. That avoids the entire retroactive application analysis. It's a separate question. Just because some violation has occurred does not mean that you will receive the benefit of that earlier case. This court has cases talking about overruling decisions, and we have Teague. Now, Mr. Ney is correct that you don't need to be bound by Teague, but that doesn't mean that you can't use Teague as you've used it in the past. Just simply to say that we find ourselves in a situation where the statute that the defendant was convicted on, or I'm sorry, not convicted, but sentenced under, was eventually found to be unconstitutional, does not mean that it is automatically applied retroactive. That's the whole point of the Teague retroactive discussion. You have to be willing to understand that, okay, as a matter of law, what happened on Monday is something that was a violation, but you've only begun the process. You then need to think about, how are we going to apply those rights to people? Is there a cutoff line? Where's the cutoff line? What are the factors? And Mr. Ney talks about the accuracy element. Every time you read a case from the United States Supreme Court talking about, hey, on the second Teague exception, we're more likely to apply it when it applies to the accuracy. They're talking about the accuracy of the conviction. Are we feeling okay with the fact that this defendant has been convicted? Not one case will you find that talks about the accuracy of sentencing. Huge distinction. Unless the court has any questions, we would again respectfully request that the defendants, that the district court's ruling be overruled.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.